During a powerful winter storm, one house on the block kept producing electricity while the rest of the neighborhood went dark. City inspectors fined the homeowner $12,000 for operating an unpermitted commercial wind turbine. They claimed he was generating power illegally. But watch the moment the judge realizes what was actually spinning behind the house.
Your Honor, I'm not running any commercial turbine. I'm a retired mechanical engineer, and that unit behind my shed is a small micro wind generator. The blades are only about 3 feet wide, and the pole is roughly 20 feet tall. It charges a small battery bank in my garage so I can run basic appliances during outages. It's completely separate from the city grid.
Your Honor, inspectors observed a rotating wind-powered device producing electricity during the storm. Under Municipal Energy Ordinance 214, power generation equipment requires registration and safety documentation. No permit or technical specifications were filed for this installation. Based on the observed output and lack of documentation, the system was classified as unlicensed energy production.
The ordinance cited by the city regulates commercial wind turbines connected to the electrical grid. The system described here is a small residential generator operating independently of municipal infrastructure. Homeowners are permitted to generate limited electricity for personal use and emergency backup. This device does not meet the threshold for commercial power generation. The citation is vacated.
The city flew a drone over his backyard and spotted a large amateur astronomy telescope inside a small dome structure. Now they're claiming he's operating an unauthorized observational tower and violating municipal airspace and zoning codes.
Your Honor, during a routine aerial survey for code compliance, our department observed a rotating dome structure in the defendant's backyard. The structure houses a mounted optical device capable of mechanical elevation and rotation. Under Municipal Zoning Ordinance 22B, any elevated observation platform exceeding accessory use parameters requires a conditional permit. The defendant has not applied for such a permit. Additionally, the structure appears to exceed standard shed height allowances. We requested access for inspection. He refused. We are seeking enforcement compliance.
It's a telescope, Your Honor. I retired 5 years ago. I look at planets. That dome rotates because the Earth does. It's 8 feet tall, shorter than my fence. No one climbs it. No one stands on it. It's not a lookout tower. They sent me a letter calling it an observational facility. I'm not tracking aircraft. I'm tracking Jupiter. And the only thing I've observed so far is how creative city paperwork can get.
The city conducted an aerial survey of private residential property. Was there a complaint? Was there evidence of commercial activity? You are applying tower regulations to what appears to be a hobby telescope. The ordinance references human occupancy. I see no staircase, no platform, no guardrails, and most importantly, no public access. This court finds that the defendant's telescope enclosure constitutes an accessory residential structure. It does not meet the definition of an observational tower. The city's enforcement notice is vacated.
For years, he parked 3 cars at his apartment complex without any issue. Now, halfway through his lease, management created a new rule limiting residents to 1 vehicle per adult and told him his 3rd car would be towed unless he paid $100 a month for a garage.
Your Honor, I've lived at this complex for 2 years. I've parked 3 vehicles there the entire time without a single warning or violation. My current lease does not mention any parking limit or additional parking fee. Last month, management announced a new rule limiting residents to 1 vehicle per adult and requiring registration. I was told my 3rd car would be towed unless I rent a garage for $100 per month. I am asking the court to enforce the lease as written.
Your Honor, the parking lot has become overcrowded. We implemented a community-wide parking policy to ensure fairness and availability. This policy applies to all residents equally. The lease includes a clause stating that residents must follow community rules and regulations. We believe parking policies fall within that authority.
I have reviewed the lease. The rules and regulations clause does allow reasonable community policies. However, those policies cannot materially alter the financial obligations of the lease midterm. The defendant may adopt reasonable parking regulations for future leases, may not impose new financial burdens, or materially restrict existing rights during the current lease term. Threat of towing under these circumstances is improper.
The plaintiff may continue parking his vehicles consistent with prior practice until the lease expires.
The HOA entered a homeowner's backyard without permission. They said it was a routine inspection. He called it trespassing. What the judge said gone viral.
Your Honor, I came home from work and found strangers in my backyard on my own security footage. They unlocked my gate, walked past my porch, and measured my fence. No prior call, no notice, no permission.
The association bylaws permit visual compliance inspections when necessary. The fence height and garden placement required verification. We followed established procedure under community.
Let me be very clear, an HOA does not become law enforcement because it carries a rule book. Entering a locked private backyard without consent is trespassing. Community guidelines do not override property rights. This court finds the entry unlawful. Case dismissed.
This woman was walking when she tripped on a raised sidewalk the city never fixed. She suffered severe injuries, and now a judge must decide who's responsible.
Your Honor, I was walking with my young nephew when my foot caught on an uplifted section of sidewalk that should have been fixed years ago. I fell hard and suffered serious injuries. I've had surgeries, ongoing pain, and daily challenges because the city failed to repair what was a known hazard.
Your Honor, the city maintains extensive public roadways and responds to reported hazards as resources allow. We dispute the extent of liability and the amount of damages being requested in this matter.
When a public entity has notice of a dangerous roadway condition, it has a duty to correct it or provide warning. The evidence supports that this defect created a foreseeable risk of harm. The case is resolved in the amount of $7.5 million.
That's today's breakdown. If you're as shocked as we are, hit follow and share this with someone who needs to hear it. More unbelievable cases are coming soon.